hate to ever say any cases are fun, but some of these cases can be when you get into these issues that are law school problems that we all talk about when we're learning about these issues. And this is one of those. Curtilage has been around for a long time, but the Fourth Amendment, under the Fourth Amendment, the importance of the home is paramount. And our Supreme Court in Tennessee and the United States Supreme Court has expanded the protection of the home to the curtilage of the home, and has attempted in some cases to define what curtilage means, although it continues to be a bit of an amorphous thing that is addressed on a case-by-case basis. Regardless, though, at the heart of the Fourth Amendment is a man's ability to retreat to his home and the curtilage and be free from a warrantless search or a seizure. It's well settled that law enforcement cannot enter into the curtilage of a home for the purposes of a search any more than they could enter into the physical structure of a home for purposes of a search without possessing a warrant or satisfying a well-delineated exception to the warrantless or the warrant requirement. In this instance, on February 16th of 2019 at approximately 1:50 a.m., the record would show that Officer Corderio Eatman of the Murfreesboro Police Department was patrolling the Northwoods neighborhood, which I am actually very familiar with, and noticed a vehicle with its running lights parked near the garage or up by the garage of a house at 1342 Shagbark Trail. Officer Eatman passed the vehicle, traveled through the neighborhood to the back to where it dead ends, turned around and came back. He testified, I believe it was about 3 to 5 minutes is how long it took him. When he came back, he found the vehicle in the same position with the running lights on. No one outside the vehicle. He couldn't see anybody in the vehicle. And he testified. By the time of trial, he was no longer employed by the Murfreesboro Police Department, and he did not testify at the trial. However, at the suppression hearing on the motion, he testified that he had been directed within the district he was covering to be heightened, his awareness should be heightened to vehicle thefts. So he couched his reason for being concerned about this underneath of that.
If I remember correctly, it's pretty specific about a bunch of auto burglaries and stuff going on in the area and be looking for suspicious cars. And one of the things with people like parked in the driveway, lights running and things like that.
I think, candidly, there is some language in the state's brief when they cite that. Officer Eatman does not testify specifically about vehicles parked in driveways. In fact, that's the officer who testifies at trial, who was an officer who came later, who does testify that something to the nature of we should be aware of vehicles parked in driveways. However, that was not at the suppression hearing, that occurred at trial. Okay. So his testimony at trial was he had been directed by the police department within the zone, which I believe, based on my best guess, covered about 8 square miles of where he was. I think it was the 3rd zone. He was to be heightened, and it included a large portion of Murfreesboro, or MTSU, the university, so it makes sense why he would be ordered within that area to be heightened to that, but that is correct, Your Honor. He did not notice anything suspicious of this vehicle, no doors open, nothing of that nature, other than the simple fact that the running lights were on the vehicle. Within the video from Officer Eatman's vehicle, you can clearly see the home. I took a screenshot, included it within my brief, so you can see the front of the home and you can see the vehicle parked on the right. I think it's important for us to notice the characteristics of the home. When you look at it, it's a wide lot. The home is spread out very wide across it. The garage is on the far right, and the door to the home is on the left. It's illuminated within the video. You can see it. The front door is. And the driveway comes to the far left, almost on the property line. It comes in front of the house, and I think the word Officer Eatman uses is serpentine driveway. He comes across and comes up over here on this side. Officer Eatman parks his patrol car directly in front of the home, and he exits it, and he walks across the grass in front of the house, up to the driveway, basically in the middle of the property, it appears, and then proceeds to walk up the driveway around to the side of the home. He does not in any way, shape, or form go to the front door. He even testifies, I had no intention of going to the front door. I had no intention of conducting a knock and talk, which was an issue at the suppression hearing. He says, my intention was specifically, his words were, to knock on that vehicle. He intended to go directly to that car from the time that he left his patrol car in front of the house. But the characteristics of the house are important because under the Dunn factors, the United States Supreme Court said it is not a strict analysis. You are to look at it as an analytical framework, and the court is to take into consideration the facts of the specific case and the facts as they existed to determine whether or not the area where the search occurred would be curtilage. Importantly, the state does not argue in their brief that there is an exception that applies in this case. They simply argue that the location where the vehicle was parked that Mr. Polk was in was not curtilage of the home.
Let me ask one question.
Yes, sir.
Whether it was the curtilage or not, if the officer is simply going to investigate a suspicious vehicle, whether it's suspicious is not as arguable, but, and I'll sort of compare this to a knock and talk. If he just walks up to the home, whether it's in the curtilage or not, and a knock and talk knocks on the door, or whether he walks up to the car to see if there's a burglary going on, and the officer then smells marijuana, doesn't that allow the officer then to go further and investigate the smell?
Yes, but there are many issues there that I'd like to break down here, if I may. So the first, I'll work backwards. So the issue on the plain smell, at the time that, obviously the court's aware there are issues with plain smell now, considering we have marijuana versus CBD versus Delta-9, all those issues. At the time of this case in 2019, plain smell was valid. It was basis for probable cause. There's no issue there. If he can get to the vehicle, then my client has a problem. He can't really argue at that point that he didn't have plain smell, he couldn't then investigate, and then what comes out of that is problematic for him, obviously. But where the issue arises for Officer Eatman and for the state is, how does he get to the location that he's at? In order for him to enter into the property, if it's curtilage, if the property is curtilage, then he is no different than if he was entering into the home. And the example, in an attempt to break it down very simply for anyone reading the case, that the court in Collins versus Virginia, the example they use is, if you take the motorcycle from Collins and you put it in the living room of the house, there's no argument. If you walked up to the front, to the window of that house, looked inside, saw the car, the motorcycle, and knew that it had been involved in illegal conduct, officer cannot go inside that house to get that without a warrant. Can't. So the same thing applies to curtilage. You don't change the analysis just because it's outside if it's within the curtilage. So in this situation, Officer Eatman, in order to get there, to get to the home or to the car, if it's in the curtilage, has to have an exception to the warrant requirement. And he does not, because what I would think would most apply would either be a knock and talk or an exigent circumstances. But exigent circumstances would require more than simply suspicion of what this vehicle is doing, because he doesn't say that he saw anybody doing anything or committing a crime. He just simply says lights are on in the vehicle. That could mean many things, but none of them are exigent. The second argument could be a knock and talk, which is what the state attempted to couch this under in their argument for at the suppression hearing, and then they also try to get the automobile exception, but I think that's pretty well cut out when it comes to Virginia versus Collins, where they directly address the issue of the automobile exception, how it doesn't, you can't extend the automobile exception to somewhere that you can't get to in the first place, which is the curtilage. So the best argument would appear to be knock and talk, which would be a consensual search, but the problem becomes when Officer Eatman goes to the vehicle for the specific purpose of investigating a crime versus simply going there to knock and have a consensual encounter. I think that changes the game, because the court has already dealt with, and I believe it's Florida versus Jardines, where the officers took a dog to the front door to sniff on the front door, and the court said you can't do that. You can't take a dog to the front door for the purposes of trying to find evidence of a crime. And I think that applies to what Officer Eatman did here as well, is he didn't go there for a consensual encounter, and he didn't go to the front door at all. So what that would require is for this court to hold and find that not only can Officer Eatman go to that vehicle under the basis of a consensual encounter for the purpose of investigating what he thinks may be a crime, he also would have to, you would have to extend the knock and talk from the front door to the driveway. And my favorite quote of any of the case law comes from Florida versus Jardines when they talk about the knock and talk, and it says, the implicit license typically permits the visitor to approach the home by the front path, knock promptly, wait briefly to be received, and then, absent invitation to linger longer, leave. Complying with the terms of that traditional invitation does not require fine-grained legal knowledge. It is generally managed without incident by the nation's Girl Scouts and trick-or-treaters. So I think similar here, Your Honor, is that if Officer Eatman was going to the front door, he can do that. I think he can. But the problem is when he goes up the front door, or if he was to go to the front door, he would have to go up the driveway and then break off this way and go left to the front door, not go to the right to the driveway. And I think that's the distinction, is that he can't get there. That's not a location that would be open to the public. That has a privacy expectation to it of the driveway. And if I was to find someone at my front door, I expect that. I don't expect to find somebody by my car at 1:50 in the morning when I'm parked there, regardless of what I'm doing, whether it's legal or illegal. So in my opinion, Your Honor, to sum that up, I don't believe that there is a warrant exception that would apply to Officer Eatman's conduct so long as the court finds that the vehicle was parked within the curtilage, which in my opinion, and I think the state's opinion as well, considering that's where they focus their brief, the issue is whether or not this is curtilage. The most instructive case, and this court has only dealt with, from what I can find, has only dealt with Collins, Virginia versus Collins, on one occasion, which would be State versus Wiley in 2020, which was this court. And in that case, it dealt with a campsite at Bonnaroo and whether or not the campsite was curtilage. I don't think that's instructive for us here today, considering we're dealing with a single-family home and a different expectation of privacy. So since Collins was decided in 2018, this court has not really had much occasion to deal with the implications of that case for purposes of its Fourth Amendment jurisprudence. However, and I think you'd find this in my brief, in my opinion, Collins is very instructive for this court on how to handle this situation of a vehicle parked in the driveway. In Collins, similar to this case, there was a driveway that ran up the side and it ran all the way to the house. And parked by the house, admittedly a distinction here, within a low-walled area. It was about, they say car high, so probably about this high, brick wall that ran around two sides and then the house. So you had a little bit of an enclosure, but not covered, just a wall. You had a motorcycle that was under a tarp. The officer in that case believed the motorcycle had been involved in a crime. And what he did was he walked up the driveway, pulled the tarp off, took a picture, realized it was that motorcycle, put it back on, walked away, got a warrant, came back, and then arrested the homeowner. In the decision, which was mixed between the trial court and the appellate court, the Supreme Court found that that motorcycle was within the curtilage of the home, even though it was an open driveway, but for the wall on the side. And what Virginia was trying to get the court to do was make a bright line rule that a vehicle within a driveway, when viewable from the road, could not be curtilage because it's viewed by passerby. However, the Supreme Court said that the ability to observe the curtilage from a lawful vantage point is not the same as the right to enter the curtilage. Had Officer Eatman decided he wanted to sit in his police car and watch for 2, 3, 4, 5 hours outside of that house, he could have done so. But without some reason for him to go into the curtilage of the home, he, at that point, doing so, violated the Fourth Amendment. He had to have a warrant for that. So ultimately, Collins determined that the driveway is entitled to protection under certain circumstances, but then there are cases that I think probably better dealt with on my rebuttal, but there are cases where driveways have been deemed to not be protected as curtilage. However, those are distinguishable from the case at hand. In this situation, based upon the characteristics of the house, how the car was parked, where it was parked, what was going on, and the facts as a whole, I think it's clear that my client had an expectation of privacy in where he was. And in the time of night and in what he was doing, there was nothing that indicated any suspicious activity other than simply a car with the lights on. So, Your Honors, I would ask that the court reverse the trial court and suppress the evidence based upon the violation of the Fourth Amendment.
All right, thank you.
Thank you.
Good morning.
Good morning, Your Honors. May it please the court, Brooke Huppenthal on behalf of the state. This court should uphold the trial court's denial of the defendant's motion to suppress because the officer's entry onto the property was not a search for purposes of the Fourth Amendment. As the defendant noted, our argument is that the area where the defendant was parked was not the curtilage of the home, and the officer had an implied license to be in that area. And I'd really quickly like to clarify the facts. As Judge Campbell, you noted, the Murfreesboro Police Department had placed a special watch on the defendant's neighborhood, and in the proof during the trial, it was established that the department had clarified and explained cars parked in different directions and cars sitting idle with their running lights on in driveways would constitute suspicious activity. And this court can consider both the proof at trial and at the suppression hearing in this case. The officer here had observed around 2 a.m. the defendant's car acting in a way, or it was consistent with how the department had described what an officer would expect to see if someone was observing or committing a car burglary. It was parked in front of the defendant's parents' home on his driveway. It was in an unenclosed area, and there were no barriers or erected blockages for the officer to enter that driveway. Initially, I want to point out this case is distinguishable from Collins versus Virginia. In Collins, it dealt with a motorcycle. It was at the end of a driveway, but it was underneath a tarp, and it was within a partially enclosed area. We don't have either of those in this instance. The state would argue that the officer in Collins likely had an implied license to be where he was, but that implied license did not extend to the officer searching through and going under a tarp. The scope of the license, the implied license, is what's important in this case. The officer had acted or had entered an area where there was no barrier and it was routinely accessible to the public. For example, let's say a FedEx driver had come to the home to deliver a package. It would be reasonable for that FedEx driver to drive up to the area where the defendant's car was, walk to the front door, deliver a package, and leave. And the distinguished element between that example and perhaps Collins would be the FedEx driver couldn't go to the front door and open the homeowner's packages. So we're looking at the area and what society would expect as reasonable. And in this case, the officer was conducting a legitimate business, or he was entering the property to use a passageway for legitimate purposes, and that does extend to official police activities. And any person that's intending to conduct business with the property owner here would have access to that same location where the officer was. Under the done factors, this area where the defendant had parked his vehicle was not curtilage. Looking at the proximity to the home, the driveway had extended up into the left side where the garage was, but there was another car parked in between. The car wasn't immediately in this area of where the home was. There was, again, it's not disputed that there was any enclosure over the defendant's vehicle. And looking at the nature of the use of the area, there's no proof in the record that the home life, activities of the home life had extended to this area. And the nature of the use, it naturally coincides or intersects with the implied license. So the officer was in this area and was acting within the implied license, which would be a natural use of the area. I would assert that there's no expectation to privacy for a vehicle that has its running lights on at 2 a.m. sitting on a driveway. As we saw a photo in the defendant's brief, it's obvious that this officer could see the vehicle from the public roadway. And the defendant talks about how the length of this driveway is important to the analysis, and really it's a red herring here because the length of the driveway is irrelevant. It's whether do we have a barrier to entry. And that's what the Tennessee Supreme Court held in Christensen. In that case, there were no trespassing signs, and the court held that that was insufficient for a homeowner to revoke the license. Here, there was no barriers. There was no effort by the property owner to prevent passersby from seeing this area. It wasn't protected from any observation. And in this case, because there was no barrier, the implied license wasn't revoked. And for that reason, not only was the area not curtilage, but the officer had an implied license to be in that area. And so even if this court does find that the area was curtilage, the officer was acting within the implied license. And again, in Christensen, the Tennessee Supreme Court, in that case, the court didn't decide on whether or not the driveway constituted curtilage. It assumed that the area was curtilage for purposes of analyzing the case. But even if it was, an officer can be in an area that constitutes curtilage, but doesn't necessarily violate the Fourth Amendment if they're acting within their implied license. And in that case, we did not raise any issue with any exceptions to the warrant requirement because there was no intrusion. So even if it was curtilage, the implied license here allowed the officer to be in the area. There was no warrantless intrusion. And for that reason, this court should uphold the trial court's judgment. And unless there are any questions, we ask that this court affirm. Thank you.
Thank you, General. Mr. Lewis,
Yes, Your Honor.
rebuttal.
Yes, sir. There are a couple of points to be made. I want to point out in the reply, or in the responsive brief to my original brief, there were a line of cases that were pointed out, a couple of which predated the findings in Collins, and all of those were used to suggest that a driveway was not or is not considered curtilage. All of those cases, including Mayshaw, which was after Collins, all of those cases dealt with driveways significantly different than the one in this case. In a couple of them, they were very short driveways. In one instance, it was basically a step from the driveway to the sidewalk, where it was someone on the sidewalk could easily look inside a vehicle and see what was inside. In Mayshaw, it was an individual who had his vehicle parked in a carport, but it was a public carport, not assigned to him, not his driveway. It was an apartment complex or something of that nature. In all of those cases, there was a public aspect of this. And what's interesting is that there was discussion, a lot of discussion in the state's argument of an implied license for the officer to have entered into the driveway and to be where he was. That seems to be the argument of a knock and talk, essentially, of they have the ability to be there because the public is invited to that area. However, I would submit to this court that that's simply not the case in this situation. When you take into consideration the facts of the case, it would be very strange to have any individual standing by your driveway, and would be concerning if you had someone standing by your driveway at 2 a.m. Even FedEx drivers, which I think was one of the arguments used, a FedEx driver, in order for you to move where they deliver their package from your front door, you have to actually ask for that. Like, it has to be permission from you to be able to do so. There's not an implied license to go put it by the garage. There is, in fact, you have to give them an express direction to do so. In this situation, there's nothing that indicates an implied license for Officer Eatman to have entered into the driveway to come approach this vehicle. He didn't speak to anybody. He didn't have any indication other than the fact that there were running lights that would have implied he can come there. He could go to the front door, but that would have been a split off that would have left him 20 to 40 feet away from this vehicle, not in a position, in facts we don't have, but likely not in a position to be able to have a plain smell 20 to 40 feet from the vehicle, and then split off to the left and go to the front door. I think it is important, not because of the length of the driveway, Your Honors, but because of the nature of the property itself, that the vehicle was on one side and the front door was on the other. And in order
Let
to
me
get
ask you
Yes.
one question.
Yes, sir.
Is it your position that Officer Edelman, is that his name?
Eatman.
Came up on the property with a purpose to search?
Yes.
Okay, so it's the defendant's position that the reason he came on was to search this vehicle?
Correct. To search for evidence of a crime. And to further investigate whether a crime was taking place. I don't think there's any indication. Had he said, I'm coming to the front door to speak to someone or something of that nature, but he did not. He specifically said, I was going to that vehicle to investigate further.
Was there I've read, all this stuff, it's hard to keep up with, it's
Yes,
not
sir.
my notes. If I remember correctly, there was sort of a side door with a light on close to where the vehicle was. Is that wrong?
I don't believe there's a light. There's no light on
Okay.
here. If you look at the picture that's in our brief, it is dark on that side. The only thing you can see are the running lights on that side. I believe there is an entry door to that side, but in one of the cases, it may have even been Collins, one of the cases, the court cites favorably for curtilage that you can enter from that door. But in another case, there is discussion, I don't think it's a Supreme Court case, there's discussion of an entryway being potentially an implied license. So if you were, let's say for example, the only entryway to that home was by the garage, then there would be potentially an implied license to that. However, there's not an implied license simply because it is a way to get into the home. And I believe it was Collins, I may be, don't quote me on that, Your Honors, but I believe it's Collins where they discuss favorably that there was an entryway into that as well from where the motorcycle was parked, similar to the garage. There's a door there, but it's not the door you would go, if you're coming to the house to come deliver a package or to knock on the door or to, sell Girl Scout cookies, for example, you're not going to this garage door over here. You wouldn't even see it from your entryway. You would go to the front door to the left of the home, which would put you quite a ways away from where this vehicle was. So, unless
Well, I
the court
hope
has,
the Girl Scouts aren't out at 1:50 a.m.
I sure hope not. Or trick-or-treaters, Your Honor. I don't want any trick-or-treaters in my house at 1:58 either. All right. If there aren't any more questions, I'll conclude there, and I'd ask the court to reverse and remand this for further determination. Thank you.
Thank you, Mr. Lewis. Appreciate the good briefs and the excellent arguments by both sides. We'll take it under advisement. Mr. Lewis, were you appointed on this by any chance?
I was not. I was retained, Your Honor.
All right, I just don't think I've seen you up in this court before, and I want to compliment you on how well you've done. I hope we'll see you up here again.
Yes, sir. Thank you very much.
Yes, sir.